Hi everyone, Lee Pacchia here, and you're watching the Markman Minute, where we take a look at the busy intersection between IP law and investing. As always, we're joined by Gaston in his office, where he has this awesome punching bag thing. I didn't know you were into boxing. How often are you working that thing, Gaston?
I try to get to it at least once or twice a week. I try to work out in the mornings before I head into the office, but hitting the heavy bag makes a lot of noise, but it's great for getting rid of some of the stress.
Right on. So what are we talking about today? What do you have for me?
Well, actually, there's some pretty big news out of the Supreme Court, actually. Obviously, whenever the Supreme Court takes an interest in patent issues, people tend to get excited. Everything from the Alice decision that we've talked about in the past, which impacted on the value of software / business method patents, to some of the earlier decisions like KSR and eBay. These are decisions from the late 2000s that are continuing to impact on how we practice patent litigation today. Every time the Supreme Court speaks, as you can imagine, it tends to have a ripple effect throughout the whole patent ecosphere, which obviously has an impact on the value of patents and automatically becomes of interest to investors. So the latest news is that the Supreme Court has decided to take its first look at the IPR regime that we've spoken so much about in the past and continues to be a major area of focus for investors in light of the filings by people like Kyle Bass, and as well as the general use of the IPR system as a standalone proceeding that has probably been the single greatest impact to the practice of patent litigation, at least in my career, if not most current patent practitioners. So the case in front of the Supreme Court has obviously made its way through the Patent Office, went up to the Federal Circuit. The Federal Circuit ruled. The Federal Circuit declined to take it en banc. And it's one of the early IPRs in a case called In Cuozzo, I believe is the best way to pronounce it. And while the underlying case is not that remarkable, and to be honest, I would imagine that most patent lawyers have never even read the patent at issue or really care about whether or not it's valid. What's interesting is that the Supreme Court has taken the case and decided that they're going to address two questions. And both questions promise to have a very significant impact on IPR practice going forward, and as a result, whether or not investors really need to continue to watch this IPR regime.
So what exactly are they going to be looking at?
Well, they're really going to be looking at two things. One is they're going to be looking at the PTAB, which is the administrative law judges that take a look at these IPRs and decide them. They use a standard for construing the claims of the patents, what we call the broadest reasonable interpretation. So if you have a patent claim that's directed to a chair, and I'm working on the broadest reasonable interpretation of that, basically any chair would fall into it. And that's traditionally been the PTO's standard for dealing with claim construction before the PTO. And remember, IPRs are PTO-based proceedings, so the fact that the PTO decided to implement a broadest reasonable interpretation standard was not that surprising. Why do people not want the broadest reasonable interpretation standard? And that's because patent owners feel that if their patents are construed too broadly, that can help bring in some of the prior art that's been used to invalidate it. So the patent owners are generally wanting to use what we call the Phillips standard, which is the claim construction standard that's used based on another Supreme Court case, which is how patents are litigated in a federal district court. So this is all pretty confusing, but the upshot is very simple. The PTO and the PTAB have been using a broader standard for construing the patent claims, which sucks in additional prior art. And patent owners that have been critical of the IPR process as a death squad for patent rights are saying, wait a second, we should be held to the same standard that you're going to use in a district court, especially since the IPI filers are often companies that are in district court litigation with a patent owner to begin with. So the Supreme Court has said one of the questions we want to decide is what's the proper claim construction standard in an IPR proceeding. Maybe a technical distinction, but it's a very important question.
Right. No, I wanted to kind of get to why that's such an important question. I mean, as you said, it's I mean, we're looking at technicalities here. What are the broader implications of what the court is going to be deciding on here, and what's it ultimately going to mean for the markets?
Well, I think for the markets, it really depends on what sector they're interested in. The classic example of an IPR and what an IPR was, basically put in place to do was to provide a company, and we could use Google or Facebook or whatever other big technology company you want to use. Let's assume a situation where they're sued in district court by a non-practicing entity. Now, the problem with district court cases is that they take many years and sometimes many millions of dollars to resolve. And IPRs were designed to allow for a quicker, more economical process for the defendant in those cases to try to invalidate the patent. Now, if I'm trying to invalidate a patent, I have to point to what we call prior art or prior references or disclosure about that basically say this invention was already taught and known to people or was an obvious next step for the patent owner. In district court, the patent owner has an advantage in keeping out prior art because we use what we call a Phillips claim construction standard, which actually looks at the patent itself, looks at what the patent teaches, and decides, okay, based on this teaching and this patent, what do the words in the claim mean? What's the scope of the property right? In a PTO proceeding, when you're trying to get your patent in the first place or under a re-examination or other PTO review, they use what's a broadest reasonable interpretation, which can be very, very much divorced by what the patent actually teaches. And that can have a very big impact on the ultimate result. But the thing to keep in mind, and investors need to keep in mind, is that if the IPR system goes to a Phillips standard for claim construction, the general consensus is it's going to be much more difficult for challengers filing these IPRs to be successful. Whereas if they keep the broadest reasonable interpretation, then the IPR process will continue to be a good way to try to challenge patents and get them, out of the way.
So, Gaston, before we go, there's a second issue that the Supreme Court's going to be looking at in this case, isn't that right? What's that about?
Okay, so the second issue, Lee, is a much more simple one than what we've been talking about with respect to claim construction standards. And that's whether or not the decision by the PTAB to institute an IPR is appealable. Institute or not institute an IPR is appealable. We've talked a lot in the past about Kyle Bass's IPRs and the market impact of institution decisions. Just as a very brief reminder for people, if I file a petition for IPR today, within 6 months, the Patent Office has to make a substantive determination whether or not to allow that IPR to proceed. The rule has been until now and until the Supreme Court speaks on the question that the PTAB's decision whether or not to allow my IPR to go forward is not an appealable decision. That the only decisions that are appealable from a PTAB proceeding in an IPR are what we call the final written decision post-trial. So the question for people that are interested in the market and interested in the IPR process is if IPR decisions, institution decisions are allowed to be appealed based on a Supreme Court ruling to that effect, how will that change practice, whether or not it will introduce additional risks for patent owners, for challengers that were denied institutional IPR to immediately take up their challenge to an appeals court. So again, it's more of a procedural question, but it could be important going forward. I'll finish with one point, and that's something that I saw today, which is at least a suggestion out there that because of the importance of this Supreme Court review, there are already starting to be some calls that maybe the IPR process should be stayed in totality until the Supreme Court rules on these fundamental questions. I think that's a remote kind of academic type of argument. IPRs are, the PTAB has been so busy with IPR petitions that it would be inherently unfair to anyone that's in this process to have to wait 6 months to a year for the Supreme Court to rule. But I think even the suggestion that IPRs be stayed pending decision shows the centrality of the questions that the Supreme Court's going to be decided. So we'll wait to see how it plays out.
Good stuff. Gaston, thanks for your time today, sir.
All right. Thank you, Lee. Take care.
So that's what we have for the week. If you'd like to see more of the stuff we're working on, be sure to go check us out online. You can find us under the IP Flow tab on MimesisLaw.com. We're also on Facebook, LinkedIn, and Twitter. If you liked today's interview and you're listening over podcast, be sure to give us a good review on iTunes. It makes all the difference in the world. If you're watching us on YouTube, subscribe to our channel. There's more good stuff coming. I'm Pacchia. Thanks for watching.